Cette conférence révèle un profond engagement de la part des animateurs et des participants de cet événement. C'est dans ce même esprit que je tiens à faire une modeste contribution. Mon intervention touchera le fléau et le crime de la torture. L'interdiction de ce fléau et de ce crime est sans exception et absolue en droit international. À ce sujet, un consensus, une opinion commune subsiste, mais il faut constater qu'un grand écart existe entre les normes proclamées et la réalité dans tout le continent. Il n'y a pas seulement un écart qui touche nuisiblement les normes, mais en plus une érosion des valeurs qui fait ébranler l'acquis moral et humanitaire. Cette tendance alarmante est aggravée après la date fatale du 11 septembre 2001, dans le cadre de la guerre qu'on a proclamée contre le terrorisme. C'est en quelques mots la portée essentielle de ma brève intervention qui sera prononcée en langue anglaise. On the title, Torture as an Instrument in the so-called War on Terror. This title is perhaps ambiguous. Is torture an instrument, or is it a plague or sickness? It is at least a crime, no less and no more, a crime against humanity. And war on terror was a political concept, not a legal one. The new administration in the United States under the President Barack Obama has formally abrogated the term, and correctly so. Torture is persistent in all continents, also in Europe. The European Court on Human Rights has condemned acts of torture and ill treatment in numerous European countries, including Spain, Turkey, the United Kingdom, France, Russian Federation, etc. Torture is not only persistent, it is rampant in previous and current situations of armed conflict and severe repression. Let me mention some examples, some historical ones, some present ones. I recall the civil war in Spain. There the book is formally closed, but not in the minds of the people, and the scars remain. World War II. The Gestapo, the German secret police, with its torture chambers, its scientific experiments on human beings, and the name of the famous, or rather infamous, Dr. Mengele is well known. We had the colonial wars, with torture included, in Algeria, in Southern Africa, in the Netherlands, East Indies, now Indonesia. And impunity prevailed. Are the books closed? We can turn back and turn forward in the pages of history. But are the victims and their descendants still entitled, I think so, to the right to truth, closely linked with the right to justice and the right to reparation? And there are other struggles involving the issue of self-determination in Northern Ireland, in the Basque country, in the former Yugoslavia, and now still in Sri Lanka and other places, to name a few. And there also practice of torture and ill treatment are rampant. We had the ideological conflicts in the name of what was called the national state security. The Pinochets, the Videlas in Latin America and others, and their torturers. Many of them were trained in United States military establishments. And more generally, also now, we have sexual violence, including rape, forced pregnancy, used as a tactic of war, condemned by the United Nations Security Council, expressing concern that civilians, particularly women and children, account for the vast majority of those adversely affected by armed conflict. And gender-based crimes, which may still constitute war crimes and crimes against humanity, and also constituting torture, are specifically included in the Rome Statute and form part of its proceedings. It's interesting that gender-based crimes were never charged by the Tokyo and Nuremberg tribunals, but I think that is now very much also a new awareness that also sexual crimes can amount to torture and crimes against humanity and are crimes under international law. Now we had legal responses in international law. In fact, I think still the basic document is the Universal Declaration of Human Rights, in which you participated already. And I'm so happy to see you, Mr. Ambassador, because when I served in Geneva, you were one of the defenders of my positions, which was weak sometimes. You and the Canadian ambassador were my strongholds and those who I wanted to consult from time to time, and you were always happy and available to serve in that position, not only as an excellent ambassador of your country, as also the patron of the troupe de Ormeaux, the Théâtre, and I think you were a firm defender of human rights. I'm so happy to sit with you at the same desk, at the same table. Well, the Universal Declaration, I think that still is the basic document responding to the cruelties and atrocities of what happened in World War II, and in addition to that, in international humanitarian law, the Geneva Convention of 1949, and they are all very clear on the prohibition of torture without any exceptions. Well, in the whole architecture of human rights instruments that was built up in later years, I think a lot of attention has been paid both in international instruments and in regional instruments in Latin America, in Europe, and in Africa to the prohibition of torture. I'm not going to spell all these instruments out. It's not a lecture that I'm going, but we are here in a discourse of a different nature. But the main characteristics in all these instruments is that the prohibition of torture is absolute. There is no derogation from it under any circumstances. And it is an imperative norm of international law as jus cogens. It has many legal consequences, not to transfer persons to other countries where they may be serious risk to be subjected to torture, the principle of non-refoulement, the duty to criminalize torture in law. And it is still remarkable, or not remarkable, but a pity that this is not being done sufficiently in all countries. And neither the duty to investigate. Most practices of torture are not and acts of torture are not properly investigated. The duty to prevent and the duty to award reparation to victims. And there is an opinio juris and a general consensus that torture is absolutely unadmissible under all circumstances, and that it carries a stigma, as the European Court of Human Rights said. I'm not aware of any government or other public authority that would condone torture, at least before 9/11, before the so-called War on Terror. When allegations of torture were made, usually the answer by governments is a denial of the practice, a denial of the facts, a misconstruction or interpretation of the law, and sometimes they may admit it was an incident, but not a practice. Now, what is of great concern to me and to many of us is the erosion of this consensus under the syndrome of 9/11 and the so-called war on terror. The premise was that at the end, fighting and suppressing terrorism justified whatever means were chosen. It's somehow reminiscent also of times when fighting communism was justified all kinds of breaches of the rule of law. Now the Abu Ghrabs and the Guantanamos are many, but they became public symbols of a wide network of torture practices facilitated by means of extraordinary renditions, secret detention camps, incommunicado detention, indefinite incommunicado detention without the right of habeas corpus, so as to have the legality of the detention reviewed by a judicial authority. And also this practice may amount to temporary or even definitive forced disappearance. There are still persons unaccounted for who were secretly detained, and some of the names are known, some of them are unknown. They were, in fact, these persons, these suspects, were in the position described in the title of a book written by Jacobo Timmerman, the Argentinian author, who was held also in the jails of the Argentine Dirty War. And the title of his book was Prisoner Without Name, Cell Without Number. Those who are in that position are reduced to non-persons. Now, revealing in the last few years were the so-called torture papers, which were made public thanks to the persistent efforts of non-governmental organizations and institutions and groups, such as in the United States, the American Civil Liberties Union, the Center for Constitutional Rights, Amnesty International, and Human Rights Watch, and others. These papers were written by career ideologists, lawyers, who were working in the office of the legal counsel of the Justice Department in Washington. And these papers were addressed to the Central Intelligence Agency, the CIA. They provided cynically and in great detail a legal justification for practices that by all accounts, also in the authoritative opinion of the International Committee of the Red Cross, by all accounts constituted torture or inhuman, cruel, inhuman or degrading treatment. Among them were suffocation by water, the so-called waterboarding, prolonged stress standing, prolonged nudity, sleep deprivation and the use of loud music, exposure to cold temperature, cold water, all in a frequency and a degree of intensity depending on the cooperation of the suspected terrorists. The prohibitions of human rights law and international humanitarian law were argued away by these lawyers as inapplicable and also inconvenient and having no direct effect. Now, who are the actors and accomplices in this process of erosion? I mentioned these lawyers in the office of the legal counsel in the Justice Department, acting, as I would call them, Schreibtischfolterer. We had in the Nazi period Schreibtisch, murderer. That was desk. Those who were sitting at the desk and writing and in fact justifying or inventing certain arguments. We had also, and that is another sign of erosion, academics, prominent professors, who argued that under certain strict conditions, torture should be permitted as an aggressive form of interrogation. And politicians, failing to raise their voices against torture practices because they did not want to come across as soft in fighting terrorism. And more globally, many nations and their intelligence agencies forming part of secret counter-terrorism networks and resorting to torture as a standard practice, and following suit also the countries that were already known for resorting to these kind of practices. All signs of erosion of values, particularly the prohibition of torture. This raises the issue of responsibility, and that is the last point I want to make, the responsibility. There's a criminal responsibility, a political and a professional responsibility. I'm focusing here on the United States. It's perhaps not fair to mention only that country, but it was the leading country in this so-called war on terror. But I think what is applicable to the United States is also applicable to quite a number of other countries. Many other nations are implicated in these practices as well. Now, the responsibility of the actors. We had in the United States, but also elsewhere, the highest authorities, the President, the Vice President, the Secretary of Defense, who masterminded, orchestrated, and authorized aggressive interrogation amounting to torture or ill treatment. Here certainly is a political and legal, maybe criminal responsibility. The criminal responsibility applies also to those lawyers whom I mentioned, who gave the green light to apply method of torture and thus became accomplices also on the basis of Article 4 of the Convention Against Torture. Also, as actors carrying criminal responsibility are the CIA personnel performing the dirty work. And last but also not least, my friends, the professional responsibility of medical health professionals attending and assisting in interrogation sessions and acting in violation of both basic standards of medical ethics. Will the United States, under the promising presidency of Barack Obama, take decisive steps towards full disclosure of and accountability for unlawful practices concerning the treatment of detainees secretly held by the CIA as part of the previous administration's strategy? Recently, an assistant United States attorney was mandated to conduct a preliminary review into whether US laws were violated. It appears for the time being that conduct of the highest authorities and the complicity of the lawyers of the Office of the Legal Counsel will not be included in the preliminary investigation, and that the narrow scope of the mandate may result in impunity for some of the most serious offenses. The basic question remains: what prevails, the legal obligation or political opportunity, so as to come to grips and repair the dark legacy of practices amounting to crimes under international law? On this score, international law is clear, but its enforcement is still lagging behind. Je vous remercie.